The injustice arising from strict liability demands that fault should be a requirement in establishing criminal liability. However, there exist practical considerations and further arguments to support a finding that in some instances, fault should not be essential in establishing liability. Where liability is imposed without proof of fault, it offends the natural sense of justice. This can be seen in Callow v. Tilston, where the butcher was liable for the sale of unfit meat despite having the meat certified as safe. Also, in Elliott v. C., where the 14-year-old girl was liable despite not being capable of appreciating the risk. Such cases lead to assertions that fault should be an essential ingredient in establishing liability. However, there are many practical reasons for imposing liability without proof of fault. Strict liability crimes have the advantage of being cheaper and easier to administer. If all such offences required proof of fault, the legal system would be unable to cope with the workload. Presently, offences such as speeding and driving without insurance can be dealt with administratively through the post, without the need for the defendant to attend court. If these offences required proof of fault, a trial would be required, and it would be almost impossible for the prosecution to prove that the defendant intended to speed or had knowledge that they were speeding. This demonstrates that it is not always desirable to have fault as an essential ingredient to establishing liability. Furthermore, strict liability crimes are generally aimed at protecting the health and safety of the public, and therefore they are needed to raise standards and act as a deterrent. Thus, it is a moot point as to whether fault should always be essential. However, if a person is unaware that they are committing an offence, it is difficult to see how they could take actions to raise standards or prevent it. For example, in Callow v. Tilston, the butcher took all precautions necessary and yet was still liable. Also in R. v. Howells, the defendant did not know the gun required a license. Furthermore, the offence of speeding is a strict liability crime, and yet it is arguably one of the most frequently broken laws. The law currently recognizes that true crimes, as opposed to regulatory crimes, require proof of fault as established in Sweet v. Parsley. However, this ignores the fact that any criminal conviction results in stigma and can affect a person's business or ability to gain employment in their profession. In tort law, arguments may be made for imposing liability without proof of fault. For example, in Nettleship v. Weston, the learner driver was held liable, despite the fact that she was not capable of meeting a higher standard and could not be said to be at fault. However, if she was not found liable, the claimant would have gone uncompensated. This would be unfair on the injured claimant, and whilst at first sight it may seem unfair to the defendant, in reality it is the insurance company that pays, not the defendant. Similarly, in Roberts v. Ramsbottom, the defendant driver had a stroke and knocked into a pedestrian. He was found liable. Again, it can hardly be said that he was at fault. However, in order to do justice to the claimant, he was held to be in breach of duty. Thus, it can be seen that fault should not always be an essential ingredient in establishing liability. It can be seen that whilst strong arguments based on justice exist for having fault as an essential ingredient, there also exist practical reasons for allowing liability without proof of fault. In summary, fault is the degree of blame attached to an individual or behavior. Generally, fault is a requirement in establishing liability, but there are exceptions to this. Principles of natural justice would dictate that fault should be required, but this is not always practical. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes.
Thanks for watching.